Title II. Crimes against the fundamental laws of the state. Classes of arbitrary detention. 1. By detaining a person without legal ground. 2. Delaying the delivery of detained persons to the proper judicial authorities. 3. Delaying release. Art. 124. Arbitrary detention elements. 1. That the offender is a public officer or employee whose official duties include the authority to make an arrest and detain persons. 2. That he detains a person. And 3. That it was without legal grounds. Notes. Arbitrary detention is the deprivation by a public officer of the liberty of a person without any legal ground, though the elements specify that the offender be a public officer or employee. Private individuals who conspire with public officers can be liable as principals. Legal grounds for the detention of any person: commission of a crime, violent insanity or other ailment requiring compulsory confinement of the patient in a hospital. Grounds for warrantless arrest: crime is about to be, is being, or has been committed. Arresting officer must have personal knowledge that the person probably committed the crime, or person to be arrested is an escaped prisoner. Relitogo VCA is an example of arbitrary detention. Judge Pimentel, Ramos v. Enral. Rebels later on retire. Once you have committed rebellion and have not been punished or amnestied, the rebels continue to engage in rebellion, unless the rebels renounce their affiliation. Arrest can be made without a warrant because rebellion is a continuing crime. Art. 125. Delay in the delivery of detained persons to the proper judicial authorities. Elements. 1. That the offender is a public officer or employee. 2. That he has detained a person for some legal ground. And 3. That he fails to deliver such person to the proper judicial authority within 12 hours. Detained for crimes punishable by light penalties, or equivalent, be 18 hours, for crimes punishable by correctional penalties, or their equivalent, or c. 36 hours, for crimes offenses punishable by capital punishment or afflictive penalties, or their equivalent. Notes. The felony means delay in filing the necessary information or charging of person detained in court, which may be waived if a preliminary investigation is asked for. This does not contemplate actual physical delivery. The filing of the information in court beyond the specified periods does not cure illegality of detention. Neither does it affect the legality of the confinement under process issued by the court. To prevent committing this felony, officers usually ask accused to execute a waiver of Art. 125, which should be under oath and with assistance of counsel. Such waiver is not violative of the constitutional right of the accused. Contemplates arrest by virtue of some legal ground or valid warrantless arrest. If arrested by virtue of arrest warrant, person may be detained until case is decided. Length of waiver: light offense 5 days. Serious and less serious offenses 7 to 10 days. Judge Pimentel. If offender is a private person, the crime is illegal detention. Arbitrary detention versus delay in delivery of detained. In arbitrary detention, detention is illegal from the beginning. In delay in delivery of detained, detention is legal in the beginning, but illegality starts from the expiration of the specified periods without the persons detained having been delivered to the proper judicial authority. Art. 126. Delaying release elements. 1. That the offender is a public officer or employee. 2. That there is a judicial or executive order for the release of a prisoner or detention prisoner, or that there is a proceeding upon a petition for the liberation of such person. And 3. That the offender without good reason delays, a. the service of the notice of such order to the prisoner, or b. the performance of such judicial or executive order for the release of the prisoner, or c. the proceedings upon a petition for the release of such person. Note. Wardens and jailers are the persons most likely to violate this provision. Art 127. Expulsion elements. 1. That the offender is a public officer or employee. 2. That he expels any person from the Philippines, or compels a person to change his residence. And 3. That the offender is not authorized to do so by law. Acts punishable. 1. By expelling a person from the Philippines. Or 2. By compelling a person to change his residence. Notes. Acts punishable. The crime of expulsion absorbs that of grave coercion. If done by a private person, act will amount to grave coercion. Crime does not include expulsion of undesirable aliens, justiciero, or one sent to prison. If a Filipino who, after voluntarily leaving the country, is illegally refused re-entry is considered a victim of being forced to change his address. Threat to national security is not a valid ground to expel or to compel one to change his address. The chief executive has the power to deport undesirable aliens. Art 128. Violation of domicile elements. 1. That the offender is a public officer or employee. 2. That he is not authorized by judicial order to enter the dwelling and/or to make a search therein for papers or other effects. And 3. That he commits any of the following acts: A. Entering any dwelling against the will of the owner thereof. B. Searching papers or other effects found therein without the previous consent of such owner. C. Refusing to leave the premises after having surreptitiously entered said dwelling and after having been required to leave the same. Special aggravating circumstances. 1. Nighttime. 2. Papers or effects not constituting evidence of a crime are not returned immediately. Notes. The judicial order is the search warrant. If the offender who enters the dwelling against the will of the owner thereof is a private individual, the crime committed is trespass to dwelling. Art 280. When a public officer searched a person outside his dwelling without a search warrant and such person is not legally arrested for an offense, the crime committed by the public officer is either grave coercion if violence or intimidation is used, Art 286, or unjust vexation if there is no violence or intimidation, Art 287. Public officer without a search warrant cannot lawfully enter the dwelling against the will of the owner, even if he knew that someone in that dwelling is in unlawful possession of opium. Art 129. Search warrants maliciously obtained, and abuse in the service of those legally obtained acts punishable. Procuring a search warrant without just cause elements. 1. That the offender is a public officer or employee. 2. That he procures a search warrant. And 3. That there is no just cause exceeding his authority by using unnecessary severity in executing a search warrant legally procured. Elements. 1. That the offender is a public officer or employee. 2. That he has legally procured a search warrant. And 3. That he exceeds his authority or uses unnecessary severity in executing the same. Notes. Search warrant is valid for 10 days from its date of issue. If there is no just cause, the warrant is unjustified. The search is limited to what is described in the warrant. All details must be set forth with particularity. Example of a warrant maliciously obtained. X was a respondent of a search warrant for illegal possession of firearms. A return was made. The gun did not belong to X and the witness had no personal knowledge that there is a gun in that place. Examples of abuse in service of warrant. 1. X owner was handcuffed while search was going on. 2. Tank was used to ram gate prior to announcement that a search will be made. 3. Persons who were not respondents were searched. An exception to the necessity of a search warrant is the right of search and seizure as an incident to a lawful arrest. Art 130. Searching domicile without witnesses. Elements. 1. That the offender is a public officer or employee. 2. That he is armed with a search warrant legally procured. 3. That he searches the domicile, papers or other belongings of any person. And 4. That the owner, or any member of his family, or 2 witnesses residing in the same locality are not present. Notes: order of those who must witness the search: homeowner, members of the family of sufficient age and discretion, responsible members of the community. Validity of the search warrant can be questioned only in 2 courts: where issued or where the case is pending. The latter is preferred for objective determination. Art 131. Prohibition, Interruption, and Dissolution of Peaceful Meetings Elements. 1. Offender is a public officer or employee. 2. He performs any of the following acts: A. Prohibiting or interrupting, without legal ground, the holding of a peaceful meeting, or dissolving the same, e.g., denial of permit in arbitrary manner. B. Hindering any person from joining any lawful association or from attending any of its meetings. C. Prohibiting or hindering any person from addressing, either alone or together with others, any petition to the authorities for the correction of abuses or redress of grievances. Notes: if the offender is a private individual, the crime is disturbance of public order. Art 153. Meeting must be peaceful and there is no legal ground for prohibiting, dissolving or interrupting that meeting. Offender must be a stranger, not a participant, in the peaceful meeting. Otherwise, the offense is unjust vexation. Interrupting and dissolving a meeting of the municipal council by a public officer is a crime against the legislative body and not punishable under this article. The person talking on a prohibited subject at a public meeting contrary to agreement that no speaker should touch on politics may be stopped, but stopping the speaker who is attacking certain churches in public meeting is a violation of this article. Those holding peaceful meetings must comply with local ordinances. Example: ordinance requires permits for meetings in public places. But if a police stops a meeting in a private place because there's no permit, officer is liable for stopping the meeting. Art 132. Interruption of religious elements. 1. That the officer is a public officer or employee. 2. That religious ceremonies or manifestations of any religion are about to take place or are going on. And 3. That the offender prevents or disturbs the same. Notes: qualifying circumstances. 1. Violence, or 2. Threats. Reading of Bible and then attacking certain churches in a public plaza is not a ceremony or manifestation of religion, but only a meeting of a religious sect. But if done in a private home, it's a religious service. Religious worship includes people in the act of performing religious rites for a religious ceremony or a manifestation of religion. Examples: Mass, baptism, marriage. X. A private person boxed a priest while the priest was giving homily and maligning a relative of X is X liable. X may be liable under Art 133, offending religious feelings, because X is a private person. Art 133. Offending religious feelings elements. 1. Acts complained of were performed, A. in a place devoted to religious feelings, or B. during the celebration of any religious ceremony. 2. Acts must be notoriously offensive to the feelings of the faithful. 3. Offender is any person. And 4. There's a deliberate intent to hurt the feelings of the faithful, directed against religious tenet. Notes: if in a place devoted to religious purpose, there is no need for an ongoing religious ceremony. Example of religious ceremony: acts performed outside the church, processions and special prayers for burying dead persons but not prayer rallies, acts must be directed against religious practice or dogma or ritual for the purpose of ridicule, as mocking or scoffing or attempting to damage an object of religious veneration. There must be deliberate intent to hurt the feelings of the faithful. Mere arrogance or rudeness is not enough. Title 3, Crimes Against Public Order. Political crimes are those directly aimed against the political order, as well as such common crimes as may be committed to achieve a political purpose. The decisive factor is the intent or motive. Art 134. Rebellion or insurrection elements. 1. That there be a public armed uprising, and 2. That the purpose of the uprising or movement is either A. To remove from the allegiance to said government or its laws the territory of the Philippines or any part thereof or any body of land, naval or other armed forces, or B. To deprive the chief executive or Congress, wholly or partially, of any of their powers or prerogatives. Persons liable. 1. Any person who promotes, B. maintains, or C. heads a rebellion or insurrection leader. 2. Any person merely participating or executing the command of others in rebellion participant. And 3. Any person who in fact directed the others, spoke for them, signed receipts and other documents issued in their name, or performed similar acts on behalf of the rebels. Person deemed leader. 1. Leader is unknown. Notes, rebellion is the term used where the object of the movement is completely to overthrow and supersede the existing government. Insurrection refers to a movement which seeks merely to effect some change of minor importance to prevent the exercise of governmental authority with respect to particular matters or subjects. Purpose of the uprising must be shown, but it is not necessary that it be accomplished if there is no public uprising. The crime is direct assault. Mere giving of aid or comfort is not criminal in the case of rebellion. There must be actual participation. People versus Hernandez ruling. Rebellion cannot be complexed with ordinary crimes done pursuant to it. People versus Geronimo ruling. Crimes done for private purposes without political motivation should be separately punished. Enrile versus Salazar ruling. Upheld Hernandez. Thus, rebellion absorbs other crimes committed in furtherance of rebellion. Illegal possession of firearms in furtherance of rebellion is absorbed by the crime of rebellion. A private crime may be committed during rebellion. Rape, even if not in furtherance of rebellion, cannot be complexed with rebellion. Rebellion is a continuing crime along with the crime of conspiracy or proposal to commit rebellion. If killing or robbing were done for private purposes or for profit, without any political motivation, the crime would separately be punished and would not be embraced by rebellion. People v. Fernando. If the leader is unknown, a person is deemed a leader of rebellion if he A. directed the others, B. spoke for them, C. signed receipts and other documents issued in their name, and D. performed similar acts on behalf of the rebels. Diverting public funds is malversation absorbed in rebellion. Public officer must take active part. Because mere silence or omission is not punishable as rebellion. In rebellion, it is not a defense that the accused never took the oath of allegiance, or that they never recognized the government. Art 134a. Coup d'état elements. 1. Offender is a person or persons belonging to the military, or police or holding any public office or employment. 2. Committed by means of swift attack, accompanied by violence, intimidation, threat, strategy or stealth. 3. Directed against A. duly constituted authorities of the Philippines. B. Any military camp or installation. C. Communication networks, public utilities or other facilities needed for the exercise and continued possession of power. 4. For the purpose of seizing or diminishing state power. Persons liable. 1. Any person who leads or in any manner directs or commands others to undertake coup d'état. Leaders. 2. Any person in the government service who participates or executes directions or commands of others in undertaking coup d'état participants from government. 3. Any person not in the government service who participates, or in any manner, supports, finances, abets, or aids in undertaking a coup d'état participants not from government. And 4. Any person who in fact directed the others, spoke for them, signed receipts and other documents issued in their name, or performed similar acts, on behalf of the rebels, deemed leader if leader is unknown. Art 135. Penalty for rebellion, insurrection or coup d'état who are liable and penalties. Rebellion. 1. Leaders. Reclusion perpetua. 2. Participants reclusion temporal. 3. Deemed leader. Reclusion perpetua coup d'état. 1. Leaders. Reclusion perpetua. 2. Participants govit. Reclusion temporal. 3. Participants not govit. Prison mare. 4. Deemed leader. Reclusion perpetua. Art 136. Conspiracy and proposal to commit coup d'état, rebellion or insurrection. Elements of conspiracy. 1. 2 or more persons come to an agreement to rise publicly and take arms against the government. 2. For any of the purposes of rebellion. And 3. They decide to commit it. Elements of proposal. 1. A person who has decided to rise publicly and take arms against the government. 2. For any of the purposes of rebellion. And 3. Proposes its execution to some other person. S. Proposal to commit rebellion versus inciting to rebellion. In both, the offender induces another to commit rebellion. In both, the crime of rebellion should not be committed by the persons to whom it is proposed or who are incited. If they commit rebellion because of the proposal or inciting, the proponent or the one inciting may become a principal by inducement in the crime of rebellion. In proposal to commit rebellion, the person who proposes has decided to commit rebellion. In inciting to rebellion, it is not required that the offender has decided to commit rebellion. In proposal to commit rebellion, the person who proposes the execution of the crime uses secret means. In inciting to rebellion, the act of inciting is done publicly. Notes: organizing a group of soldiers, soliciting membership in, and soliciting funds for the organization show conspiracy to overthrow the government. The mere fact of giving and rendering speeches favoring communism would not make the accused guilty of conspiracy if there is no evidence that the hearers then and there agreed to rise up in arms against the government. The advocacy of communism or communistic theory is not a criminal act of conspiracy unless converted into advocacy of action. Only when the communist advocates action and actual uprising, war or otherwise, does he become guilty of conspiracy to commit rebellion. People versus Hernandez. Art 137. Disloyalty of public officers or employees acts punishable. 1. Failing to resist rebellion by all the means in their power, or 2. Continuing to discharge the duties of their offices under the control of rebels, or 3. Accepting appointment to office under rebels. Notes: there must be actual rebellion for this crime to be committed. It must not be committed in conspiracy with rebels or coup plotters for this crime to be committed. If position is accepted in order to protect the people. Not covered by this article. Art 138. Inciting to rebellion or insurrection elements. 1. That the offender does not take arms or is not in open hostility against the government. 2. That he incites others to the execution of any of the acts of rebellion. And 3. That the inciting is done by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same end. Notes: inciting must have been intentionally calculated to seduce others to rebellion. In both proposal to commit rebellion and in inciting to rebellion, rebellion should not actually be committed by the persons to whom it was proposed, or who were incited. If they commit rebellion because of the proposal or incitement, the proponent, or the one inciting may become a principal by inducement in the crime of rebellion. Proposal to commit rebellion 136 versus inciting to rebellion 138. In a proposal to commit rebellion, the person who proposes has already decided to commit rebellion. Whereas in inciting to rebellion, it is not required that the offender has decided to commit rebellion. In proposal to commit rebellion, the person who proposes the execution of the crime uses secret means. Whereas in inciting to rebellion, the inciting is done publicly. Art 139. Sedition elements: that the offenders rise, A. publicly, and B. tumultuously, that they employ force, intimidation, or other means outside of legal methods, and that the offenders employ any of those means to attain any of the following objects: A. to prevent the promulgation or execution of any law or the holding of any popular election, B. to prevent the national government, or any provincial or municipal government, or any public officer thereof from freely exercising its or his functions, or prevent the execution of any administrative order, C. to inflict any act of hate or revenge upon the person or property of any public officer or employee, D. to commit for any political or social end any act of hate or revenge against private persons or any social class, or E. to despoil for any political or social end any person, municipality or province, or the national government of all its property or any part thereof. Notes: sedition is the raising of commotions or disturbances in the state. Its ultimate object is a violation of the public peace, or at least such a course of measures as evidently engenders it. People versus Perez. Tumultuous uprising means that it is caused by more than 3 persons who are armed or provided W means of violence. In sedition, offender may be a private or public person. Common crimes are not absorbed in sedition. People v. Umali. Preventing election through legal means is not sedition. If the purpose of the offenders is to attain the objects of rebellion or sedition by force or violence, but there is no public uprising, the crime committed is direct assault. There is conspiracy to commit sedition, Art 141, but no proposal to commit sedition. Art 140. Penalty for sedition: persons liable, leader of the sedition, and other persons participating in the sedition. Art 141. Conspiracy to commit sedition. Note: there must be an agreement and a decision to rise publicly and tumultuously to attain any of the objects of sedition in order to constitute crime of conspiracy to commit sedition. Art 142. Inciting to sedition acts punishable: inciting others to the accomplishment of any of the acts which constitute sedition by means of speeches, proclamations, writings, emblems, etc. Uttering seditious words or speeches which tend to disturb the public peace, writing, publishing, or circulating scurrilous, vulgar, mean, libelous libels against the government or any of the duly constituted authorities thereof, which tend to disturb the public peace, or knowingly concealing such evil practices. Elements of ACT 1. That the offender does not take a direct part in the crime of sedition, that he incites others to the accomplishment of any of the acts which constitute sedition, and that the inciting is done by means of speeches, proclamations, writing, emblems, cartoons, banners, or other representations tending to the same end. Uttering and writing punishable, when they tend to disturb or obstruct any public officer in executing the functions of his office, or when they tend to instigate others to cabal and meet together for unlawful purposes, or when they suggest or incite rebellious conspiracies or riots, or when they lead or tend to stir up the people against the lawful authorities or to disturb the peace of the community. The safety and order of the government. 3 rules relative to seditious words. Dangerous tendency rule, clear and present danger rule, balance of interests rule.